I think the biggest edit when I'm editing my associate summaries is they'll use words like shall and persterpes, and I'm like, our clients don't necessarily know what that means.
When I hear persterpes, it never resonates ever.
Yeah.
Fair enough.
Yeah.
So, I don't.
Sounds like a disease.
What's a better definition of persterpes? What's an easier way
I'll
of
just
saying
say
that?
like to your descendants in equal shares, and then we'll have a conversation about it.
Easy to say. It's a much better way to say
Right.
it.
So
yeah.
it's just, meet them where they are. My clients are super smart and they're great at what they do in their lives and their businesses, but they're paying me to be an expert in this area. So I want them to feel like they understand what they're signing.
When you say shall, what does that mean?
Must,
meaning?
So if you say, for example, in a marital trust, income must be distributed annually to the spouse in order to qualify for...
shall. I thought you said shall. Okay,
shall.
Okay, understood though, but must is better
so I'll
than shall,
say the
for
income
sure.
must be distributed to the
We're not
spouse each year.
It's not Old English we're trying to speak here, so that makes a lot of sense. Yeah.
My will shall be discussed amongst tea.
There's a big scroll that's coming out.
Sounds like the hand of God is coming.
Exactly.
You shall do it this way.
Welcome to the weekly edition of the Payne Points of Wealth podcast, the podcast that addresses all the pain points that come along with creating, growing, and sustaining your wealth. Hosted by the family wealth experts at Payne Capital Management, Bob, Ryan, and Chris Payne. Please send us any questions or comments you may have to questions@paynecm.com. And please enjoy this week's episode.
For folks at home, I mean, what is an estate plan? And maybe it sounds like a basic question, but really, when you think of an estate plan, what are the basics that people need to understand?
Sure. So it's really what your final wishes are. It's really state dependent. So every state has their own rules and also their own practices of what makes sense in that state. So I'm a New York and New Jersey barred attorney, and so I can sort of speak about it from that perspective. When I talk to a client about their basic estate plan, what most people think of is a last will and testament. So you see them on TV, your final wishes. They always envision that you're going to be in your lawyer's office and it's going to be all leather and we're going to have whiskey and there's going to be a dramatic reading with family popping out of the side who are, getting it. And I dream of that day, truly. That is not
Me
how
too, Kelly, me too.
Right. That's not how it works. I'm so sorry to take that away from you. But what it really is just sitting down. It's an uncomfortable conversation. I always tell clients, I'm like going to see the dentist. No one wants to contemplate their passing, never mind their children and future generations. But it's such a gift to the next generation to consider your wishes, talk to a smart estate planning attorney that can sort of guide you for concerns you might not even know you have, and assets. So, for example, no one thinks to bring up that they have frozen embryos, but that's important to know for your estate plan, but it's not something you necessarily think to ask your estate planning attorney. So we like to think of ourselves as the client's family advisor. We're there for any issues. So for your basic estate plan, you have your will. In New York, we prefer to do what's called a revocable trust. So the word trust could be a little bit scary. I call it a fancy will a lot of times to my clients. All it does is skip probate at your death. So when you die, you have individually owned assets. Those go through probate. In New York, you can get stuck in probate for 6 to 12 months just because they're really backed up. At that point, all of your assets are frozen. Your clients don't have, their loved ones don't have access to the money. And so a revocable trust just skips that. And then you have your power of attorney and your healthcare proxy to make financial and medical decisions during your lifetime as well. So that's your basic estate plan.
So it's like TSA pre-check?
Yeah, except I'm not really yelling at you the whole time. You can take off your shoes if you want, though.
I would contend if there's a change that needs to happen in the estate, you'd be yelling at people all the time.
I am not a
And
yeller.
you're not wearing quite TSA blue today, but you are wearing blue.
That's the energy I'm trying to put out there. For sure.
TSA energy. So I have a question. So you had mentioned that probate takes a long time in New York. Is the length of time of probate what would lead to someone having a revocable trust?
Yeah, and the cost. So I'll start on length of time. Like I said, so your assets are frozen and your loved ones just don't have access. So if you were paying the mortgage, if you're paying bills, if you want your funeral expenses covered, if you are stuck in probate and there's no other money, they will not move faster. I mean, the clerks do a great job at trying their best. They're just overwhelmed with the amount of applications they have. So for probably the last decade in New York, similar to Connecticut, similar to Florida, where probate gets backed up and gets a little expensive, instead we do these fully funded revocable trust. So it's not good enough just to sign a revocable trust. You have to take the next step and actually fund the revocable trust with your assets that would go through probate. So not every asset is a probatable asset, but for those that are, we want to make sure it's in the trust.
Makes total sense. I guess that brings me to the question, like, what are the biggest mistakes you see people make when it comes to their estate plan?
Wills have to be signed a certain way under the New York statute. So a lot of times they'll say, oh, well, I did it really quick. And I'll look at it and I'm like, it's not even signed properly. This is invalid. Or they'll do a handwritten will, not valid in New York, unless you're in the middle of war in a trench. Then, well, it's called a holographic will. It's the only time it's accepted in New York.
Specifically in trench.
Yeah, like you have to be like in active warfare for that to be validated in New York. And then the provisions are just so they're, for example, giving everything outright to their child. However, their child's in the middle of a divorce, and maybe it doesn't make sense to have those assets go outright. So it's just you know, I when people say that to me, a little bit jokingly and a little bit not jokingly will be like, okay, well, it's a lot less for me to do your estate plan now than do the estate planning litigation after you're gone and the family is up in arms over a poorly drafted document.
So Ryan's will, I think, has been done on a cocktail napkin, but it has been notarized.
Then we're good, for sure. He does seem like he's in active war there.
So
he's in the trenches.
My whole life is in the trenches.
So you and I had worked on a case a few months back where this particular individual hadn't really updated his will for, I think, over 10 years, a New York State resident. And there were some provisions in there that, he was missing out on. So, I mean, how often should these things be looked at?
Sure. So I tell my clients every 3 years or any major life event. So you have a kid, you have a grandchild, you move out of state, you come into certain amounts of money, you change your jobs, just give me a call. I'm not going to charge you just to have a phone call and just hear about your life. Most of the time we draft our documents super flexible. And so we can, they probably account for that issue, but either way, it's a 10-30 minute call, whatever it is. And I get to check in with them. I hear what's going on, or I can hear future issues that, is not an issue now, but I can see what's coming in 5 years that I can sort of flag for the future. That way, we all are on the same page.
So, we had the big, beautiful bill passed.
Mm-hmm.
And what are some of the changes and how does it affect someone's estate plan? What are some of the things that they need to address now that we've had this new big bill passed?
Lots of changes, mostly from an income tax standpoint. I'll start with the change that most impacts my practice, and that is that the federal estate and gift tax exemption was permanently, and I'll put that in quotes, increased to $15 million per individual. That means you can transfer during your life or at your death up to $15 million per individual of assets to anyone else. And if you're married, it's $30 million. It was previously, it's this year, 13.99 million. And so it's a step up. It was set to sunset at the end of this year. Now we know it's permanent. And so clients can sort of take active steps, especially those who have already fully funded their trust, used all their exemption. Now we have a little bit more wiggle room to make additional gifts or to gift assets that might be a little difficult to appraise. So if they're ever audited, we have a little bit of wiggle room to still let it fit under the exemption.
Would that be like tangible things like art?
Art's not easy to appraise, but that's not the most difficult. Like there's certain interests, like minority interests in companies, and some people will take a more aggressive discount when getting an appraisal. So any asset could be a difficult asset to appraise and properly value. But again, some of my clients, because of their wealth level, a lot of times are just audited because of the number, and there's nothing we could do. We're just sort of draft it in preparation of an audit in the future.
How often are people audited?
I found there has been a little bit of a drop off in audits. I think there are certain red flags that lead to more people being audited than the normal population. Some of that is the amount of money you have in your estate. I've seen a number of first spouses to die audits, which is surprising because there's no tax due typically at that level.
Why do you think that is?
You never know. There's, I think it's just the dollar figure. There's certain things that sort of set off alarm bells and they look into it. And most of the time, you send a few documents, it's over. They're just trying to make sure everything's done properly.
At what dollar amount is that threshold where you start to see a lot of audits?
I'd say above 50 million.
Okay. Yeah.
But again, you never know who's going to get audited. So you should be moving as if you're going to be audited, keeping careful records, getting everything appraised, making sure you're not being too aggressive on your appraisals. I see that a lot. And I'm talking to clients a lot about, I think we need to toe the line a little bit more on the side to make sure this is going to hold up.
So Kelly, what's your advice to to clients who have 20 to 30 million in net worth and probably, not going to exceed that in their lifetime. Should they start gifting now, or should they not bother?
So it really depends on the asset. So first of all, have a really solid basic estate plan. What that estate plan usually says is, so we're thinking a revocable trust. Within the revocable trust, think of it sort of as a Russian nesting doll of trusts. So you have your revocable trust on top, and then there's sort of trust for the surviving spouse as the next layer, and then there's trust for the children below that. One of the trusts for the spouse typically is a credit shelter trust. So we fund that in New York up to the New York State estate tax exemption. I don't
Which
know how
is what now?
taxy. So it's 7.12 right now?
So that should be
1216.
that amount of money typically should be segregated between spouses to take advantage of that.
Right. So we talk a lot about dividing and separating assets among spouses, just to maximize the amount of estate tax passing. But Bob,
it's $7 million per person.
per person. But the thing is that, for people at that level, we always were saying, okay, let's fully fund the credit shelter trust. As I'm reading One Big Beautiful Bill Act, as I tend to do, I'm thinking, obviously clients always get sort of a customized experience. We look at their assets, we look at their numbers. It might not make sense for every client to fully fund the credit shelter trust, because if it passes to the surviving spouse outright, then they get a step up in basis at their death. So lots to talk, we can talk forever, and I'm not an income tax attorney on Big Beautiful
But if you
Bill.
put it in the trust, typically you lose that step up in basis.
So
you
you
really
get
have-
it at your death. So there's a first step up in basis if it's in a revocable trust, but at the surviving spouse's death, you do not get a second if you're holding it in a credit shelter trust. So I think there's just more income tax planning that can be done for that middle wealth area where you're in the 20 to 30 million. Those who are, my typical client above 50 million, it's sort of stay the course. There's some non-grantor trust opportunities. There's different little things we could do depending on their assets, but for that middle sort of range, we just want to be smart about how we're distributing assets. And then typically for those clients, they have life insurance, so we'll pop a life insurance trust, get those proceeds out of their estate, because if they're in New York, they're still going to have a taxable estate. And as you may or may not know, New York estate tax is a cliff. So if you go 105% over the cliff, you're taxed at $1. So you still want to be smart about how you're setting up their estate plan.
Okay, so it's not graduated. It's like, yeah.
Right. So think of the federal estate tax like a coupon, estate tax exemption like a coupon. So you cash in your, $15 million coupon, you pay tax on the balance. New York State, it's a cliff. So if you go over the, $7 million exemption, you pay tax on $1.
Ouch.
The whole thing
Ouch.
gets pushed over.
Indeed.
Yeah, that
Well,
hurts.
Can I ask about anyone lower than that? Like if you're just starting off, I have a lot of clients who are, really growing in their career
Sure.
now, starting a family. What should I be like focusing with them to make sure that they have estate planning wise?
Most important is we need to name guardians for your children. It's horrific and terrible to think about. But if both you and your partner were to pass before your children are 18, we want to see who you want to name as guardian. A lot of young families put off doing their estate plan because they can't decide who they want to be guardians. I always sort of pause there and say, let's just get something in place. They can always change their mind. We could put successor. So maybe when you're 30 years old, your parents are a great option for your guardians, but your parents are 70 now, they're happy to take them on. 10 years from now, maybe not the best choice, but we can update your documents. It takes no time at all. There's sort of a huge barrier, I think, mentally for clients to do that first estate plan. Just get it out of the way. Find an attorney who feels right to you, who you feel comfortable talking to about these difficult conversations, and then put it in place and just know you can always update and change those provisions. For them, usually a life insurance trust, if they're doing irrevocable planning and tax planning, that's a good option. But yeah, the guardian is the big issue when they're when they are first having kids.
I see that. I think of it as like the Harry Potter clause. Like you want to make sure that they're going to like the right new parents.
They don't want to live in the Dursleys'
They don't want to
basement.
live in the Dursleys, like under the steps.
Covered from the steps.
You know what?
yeah.
It worked out okay for him in the end. Some trauma, but he
Harry
came out
actually had a big
strong.
inheritance.
Yeah, we've all seen the Gringotts Gold.
Yep.
This turned into the nerdiest podcast ever, and we were talking about tax before this.
Harry did have an estate problem, though. That's for sure.
We can use it as a case study.
But coming back on on more of like Frankie's questions and just some of the basics. I mean, you said something that really resonated in that you're kind of like the dentist. You know, people like avoid it like the plague. I mean, so many of my clients, I have to like harass them endlessly to go see Kelly Zerillo.
Right. Oh, that was personal.
Hey, hope you're enjoying the most recent episode of the Payne Points of Wealth podcast. Everything you hear on this podcast, along with some due diligence of your own, can help you get ahead financially literally at any stage of your journey. But if you want a more hands-on approach and you saved over $1 million for your retirement, Bob, Chris, Courtney, and I will run for you our total financial master plan, and we'll do that with no obligation or cost. It's a full holistic review. We literally look at everything. We'll go as far as building you your own personalized financial portal. We'll give you a bird's eye view of your entire financial life and hone in on every financial issue you need to address today, whether it's an income plan for retirement. How do you take Social Security? How do you draw from your portfolio, factor in inflation, and don't run out of money? We'll look at diversification. Markets have been wild over the course of the last couple of months. Has your portfolio been up and down? Or have you been sitting in cash, CDs, money market funds, paralysis by analysis? We'll put together a full investment game plan. We'll show you how to grow your wealth, but most importantly, protect it over the rest of your life. And we'll look at fees and taxes. Wall Street loves to sell you high cost, tax inefficient products, whether it's an annuity, mutual fund, insurance product, structured product. We'll do a deep dive of every investment you own. We'll show you how to reduce the cost and optimize your portfolio for taxes. It's not what you make, it's what you take. You'll get a full tax playbook, and we'll do this full review at no cost. We'll literally go through everything for you, do all the work up front. Simply go to www.paynecm.com/financial plan or click the link below to see if you qualify for a free financial review.
They're a young family like Frankie was talking about. If you don't name guardians, the court's going to name guardians. The court who doesn't know you and does it, your mother-in-law might seem great on paper, but actually she's in a cult and you don't really want your kids to be raised there. So it's, if you don't do an estate plan, then you're letting New York State or whatever state you live in decide what's best for you and your family. If they might have a taxable estate, I'll do sort of a worst case scenario spreadsheet showing them exactly what the tax cost will be if they don't do an estate plan. It's sort of similar to getting a prenuptial agreement. No one wants to do it, but once you sort of look at the reasons too, then it's logical to just knock it out. But on the estate planning side, what I talk to my associates about is it's our job to make them comfortable. So I meet clients exactly where they are emotionally at the time. And so if a meeting in person makes sense, great. A Zoom, a phone call, I follow it up by sending my questionnaire. They can fill it out at their pace. And then I'll come up sort of with a proposed estate plan based on the call and the plan, if that's what they want. We walk through the issues and I give them sort of bullet point, instead of looking at this overwhelming 80-page trust document, here's these 8 bullet points and sort of why they're important and what your options are. So, I'm not trying to sort of spoon feed them into any plan whatsoever, but once I sort of hear certain options in plain language, I think the biggest edit when I'm editing my associate summaries is they'll use words like shall and per stirpes, and I'm like, our clients don't necessarily know what that means.
When I hear per stirpes, it never resonates ever.
Yeah.
Fair enough.
Yeah.
So, I don't.
Sounds like a disease.
What's a better definition of per stirpes? What's an easier way
I'll
of
just
saying
say
that?
like to your descendants in equal shares, and then we'll have a conversation about it.
Easy to say. It's a much better way to say it.
Right. So
yeah.
it's just, meet them where they are. My clients are super smart and they're great at what they do in their lives and their businesses, but they're paying me to be an expert in this area. So I want them to feel like they understand what they're signing.
When you say shall, what does that mean?
Must,
meaning?
So if you say, for example, in a marital trust, income must be distributed annually to the spouse in order to qualify for...
shall. I thought you said shall. Okay,
shall.
Okay, understood though, but must is better
so I'll
than
say
shall,
the
for
income
sure.
must be distributed to the
We're not
spouse each year.
It's not Old English we're trying to speak here, so that makes a lot of sense. Yeah.
My will shall be discussed amongst tea.
there's a big scroll that's coming out.
Sounds like the hand of God is coming down. You
Exactly.
shall do it this way.
Believe it or not, Bob doesn't think Ryan and I are mature enough to talk
No,
about
Bob,
it.
you're right on that.
We're hoping in a few years that maybe
Yeah. No,
maybe Ryan and I will grow up.
I've
But
met you both. Bob's correct.
Kelly, with that, on that note, is there a way when you had 3 kids to exclude one specifically out of your will without them knowing?
Only if it's Ryan. So it's actually an interesting question because we started this off, I think, I'm not sure where this started exactly, but we were talking sort of legacy and how do we ensure your kids sort of get along? So while it's a jokey question, so clients will say, I don't think, we'll just use an unknown named Ryan as an example here. Nothing to do with this room. So they'll say, I want 2/3 to go, I want 60% to go. No, we're not doing math here. I want more of a share to go to Allie and Chris. Again, we're just guessing names here. And then for a smaller amount to go to Ryan. And they'll say, so just put that in the document. And again, my job's to listen and to do what they're saying. But what I'll say instead is, well, Ryan's going to see that document. And it might be because Ryan is so successful, he doesn't need additional assets.
Thank you, Kelly.
Again, this is a fake scenario. But they might say it that way. But Ryan, after you pass, is not going to remember that. It's not the money. It's that my parents loved me a little bit less, or they don't think I deserve as much. And there's a lot of complications around death. So there's always one kid who does more for the family when their parents are passing. And everyone has their own narrative in their head, and one's not more wrong or more right. So in that scenario, and I see it a lot, I'll say, well, why don't we make a life insurance trust, get a little bit of life insurance, have the other 2 kids be beneficiaries of that. That will not be disclosed to Ryan in this scenario. And so they can get that gifting while all 3 of them are being treated equally in the will, and Ryan will be none the wiser, assuming the other siblings don't say anything. It's sort of a jokey question, but there's no scenario I haven't seen, although, knock on wood, there's always something out there.
It's the craziest thing you've ever seen.
No comment. I've seen a lot of things, but my job is, we're never there to judge. We're just there to say, okay, here's how you want to get there, but here's a better way to get you there. And here's what's worked in the past. And so there's, my clients, I'm very lucky to have just a very trusting, smart group of individuals as my client base. And so they'll walk me through, the difficult questions. I get calls all the time saying, my kid needs to go to rehab. I'm like, great, here's 3 centers that I can get you into tomorrow. And so it's important about, knowing great advisors like Payne, and also like having the right connections to get them into wherever they need to go to solve any problem they might have.
Sometimes I get a lot of questions from clients where they're having trouble deciding who should be the executor or, the trustee. Sometimes it's because their kids are too young, or sometimes it's even a case where their kids aren't reliable. Is there a third option?
So they can always go the corporate trustee route. There's great companies out there, depending on the assets in the trust, that will serve as corporate trustee. Not always the right fit for everyone, but again, it's important as a trust and estate attorney to have relationships across the board. So we're sort of neutral, but I'll say, oh, you have this type of asset, this company handles that really well, or you have this difficult family situation, this is the company that here's 2 or 3 companies that are perfect for that. But it is a common problem. A lot of people sort of willy-nilly say let's put all 3 kids on as trustee, but they forget that means they all have to make decisions together. Maybe they don't. So I'll draft my documents saying, we could delegate powers to one trustee. So one lives in New York and is going to sign off on the documents. They can delegate that. So it's, again, you come in with sort of the issues and we just help you figure it out. And then so if your kids are too young, maybe they come in as trustee at 30. So they're 7 now. You don't know what they're going to turn out to, but these are revocable trusts, so we can change them at any point. So maybe the kids are trustees at 30, and maybe they have the power to remove and replace that independent trustees serving with them at 35. That way they have to. So in an ideal world, your kids are well over 35 by the time you pass. Not always the case, but at least that gives them some years to learn how to work with a trustee. And they'll have to replace that trustee with a new independent trustee. So someone not related to them and someone not subordinate to them.
And the idea there too is if you keep the money in trusts perpetually, it can be protected from divorce, creditors, right? So sometimes it's actually better to keep it in trust in perpetuity.
Right. I'm a big fan of a fully discretionary trust. It's in, so again, it'll say, for example, distributions could be made to Ryan for his health, education, maintenance, and support. The IRS defines
Needs
that.
lots of support, but yes.
We all know. We're aware. But the IRS defines that as an ascertainable standard. So you could be your own trustee and make those limited distributions. But if you want to go out and buy a yacht, you need an independent trustee serving with you. So it gives your child the freedom to feel like they're in control of their money. It's not that old school trust where they're locked away and they're begging for distributions to pay their rent every month. But again, it's child dependent. So that is sort of the standard estate plan if you consider anything standard. But every kid is different. Every kid has different needs. We have supplemental needs trusts that we'll create. We have all different structures depending on what fits best for the family and for their individual circumstances.
So Kelly, what about the people that are moving? I have a lot of my friends who've moved to Florida, and they're being solicited by attorneys saying, "Oh, your estate plan's out of whack because you lived in New York and now you're a Florida resident. You have to change everything." Is the state tax or the state regulations that much different state to state? Is it important to have a will registered in the state that you're a state resident?
Yeah, so I'll use New York and Florida for an example because it is a very common move, and luckily at Cozen O'Connor we have a great estate planning team in Boca Raton, so easy enough for us to say, well, let me introduce you to my colleague. We could still do the plan there. New York and Florida are different. All of your documents will say you live in, New York County, New York. And so we want to update that. Florida is happy to have you as a resident. You file a paper, you're a Florida resident in Florida's eyes. New York hates for you to be a Florida resident. So they're going to be holding on to you for income tax reasons. With two hands as long as they're possibly able to. I speak to clients all the time about how we're going to show that you're actually a Florida resident. One of them is updating the estate plan. Florida specifically has certain Florida provisions like homestead protections that should be considered. Again, I'm not barred there, so I know enough just to say the correct words and call my colleagues who are experts at it. But I know earlier we spoke about when should you call your estate planning attorney. This is a major life change that you should have that conversation. If you're working with the same firm, truthfully, our documents are Word documents. So we're just popping in the Florida provisions by a Florida barred attorney to update your plan, resending it to you. You'll sign your documents. You want, for example, your healthcare proxy. I think it's just called a healthcare designation down in Florida, but you want it to match what the doctors see all the time because you don't want to go to an ER and suddenly they're fussing around with your healthcare proxy and they can't figure it out because it's not what they're used to seeing. So even my clients that vacation, they spend the summer in Colorado or they winter in Florida, we're going to assign those healthcare proxies there as well so that they're ready to go with the same agents. So yes, speak to your estate planning attorney, update the documents accordingly, especially if you're going to still have New York property because you still have to oftentimes prove that you are a non-resident at your death.
So the baby boomers own majority of the real estate. What have you experienced with kids inheriting this real estate? Are they selling it? If you have 4 or 5 children and they're inheriting a home, right? What do they typically do? Do they sell it and distribute it that way, or do they all try and use the house if it's a nice vacation home?
So there's a few options. Again, I'll speak sort of from the New York perspective. So most people here own a co-op apartment in the city. You have to reapply, whether it's in trust, whether it's in your individual name, your kids will have to reapply as if they were walking off the street. So even if you have one kid and you want them to inherit your house, they might not be able to. Now, if you have one kid, they're probably inheriting all of your assets, so they should qualify, but a conversation I'm often having. If you have a vacation home, I always tell my clients, again, this is sort of where your online wills don't work. We can say it goes to my 5 children, but that second generation, and now they have spouses, and now they have kids, and they have different vacation time.
Very quickly.
It gets really complicated. They end up selling it. Selling it's not the worst option, but if this is a beloved family home that you have great childhood memories in, you want that to continue for your kids. So we set schedules. We set who's paying the maintenance, who's going to pay for the landscaper every year, who is going to have this week versus this week. We can be as specific as possible in these documents so that there's no fighting. My goal at the end of the day is for your family to get along and to continue to build that relationship. And I see a lot of disputes over vacation homes, and we can account for that during their life if we do it thoughtfully.
Kelly, a friend of mine, I don't know if he did it or not, but he said he was going to. He's going to be buried in a mausoleum with an ATM on the side. And the kids can only get out $250 a day. So they have to come and visit him at the cemetery if they want to get their inheritance. So not sure if he did that or not, but what's the weirdest request you've ever seen in your career?
That's a great question.
I don't know. I honestly, I've yet to see a weird request. There's sort of requests that have to be,
Cat
we have
gets everything type thing, or
well, thanks to Leona Helmsley, we can't do that. So we can't. I know you want to leave everything to Hank, but
I was gonna say that was my next question. We just watched the Aristocats, and now Hank and I are doing estate planning.
sure. Well, we can set him up with a pet trust, but it's not going to be
Okay.
all of your assets.
Kel, some people, I'm not going to name anybody I know, have a lot of expensive jewelry. And
Is
so
it you, Chris?
is everything, if you include everything in your estate plan? I mean, can the IRS audit you for jewelry that you may have somewhere?
Yeah, everything should be included. They can audit you for anything. So what I say to my clients is, normal. So that's your tangible personal property. That includes your dog Hank, to your couch, to your clothing, to your jewelry collection, your art collection, which could be your kid's art on the wall or a Picasso, which sometimes looks the same. And so it takes everything. But your Picasso is worth, $10 million when Hank might be priceless, but he also doesn't have a price.
100 million,
And so,
actually.
$100 million for Hank. Her dog is sitting outside of the room in case you can't see Bob. But we want to be thoughtful. So our normal tangible clause will say everything goes to the surviving spouse. If not the surviving spouse, my 3 kids in equal shares, how they decide. If there is something that's going to cause a taxable event, that Picasso, Hank at $100 million, we want to probably segment that out, update the life insurance or the insurance on that property to make sure it's changed to your trust, and be thoughtful about who's going to pay the taxes on that property, whether it is the person who's receiving the property or it's, your spouse or kids. So you just want to be thoughtful about it. And again, this is sort of like the vacation house. Most kids can sit down. Truthfully, most kids don't want your stuff. Everyone's holding on to so many tangibles, and the kids are like, donate, sell. And so we'll work that way. But if you think your kids are going to fight, we'll say, great, we're going to draw straws based on the age, and that's who gets to pick the straw first. And then we're going to rotate. And we can be as specific as you want in your documents. Not always needed. But again, that's why it's so important for clients to come to us and explain, tell me about your kids. Tell me about how they interact together. What are the challenges? What are your wishes? Like all of that sort of comes out, and we can account for that in there.
If I can't leave everything to Hank, can I put everything in trust and say it has to be spent on Hank?
So you can put a certain amount. I can't hold myself out to be a dog trust expert, but I have drafted them in the past. So you can put enough basically for his caretaking for the rest of his life. And so you can say like it goes to Kelly and she's going to take Hank, and you're going to leave $50,000 for his dog sit, his daycare he goes to every day, and his food because he only does farmer's dog, and his to go on vacation every year to his favorite,
his maintenance,
beach to play with his friends. So we can do it within reason. But yeah, there's a whole court cases based on that.
We have a couple basic financial questions we like to ask all our guests.
Oh gosh.
I know.
Is this your man on the street thing? Because I do fear those videos.
As you should, actually, as you should. So who was your role model? Who was your role model when it came to finances when you were younger versus now?
Same answer. My mom, always. She was stay at home as of when I came into the picture as a second born, not important enough for my brother to stop working. But I've had this audacity since I was a child, so she had to stop working. And she ran the ship at home. She paid all of the bills. She kept track of everything. She budgeted. She kept, I think we always had a good appreciation for money. We talked about charity really young. We talked about savings. We had a savings account from the time I was little. And she continues to do that to this day. She's still on top of everything. I still call her constantly being like, how do I do this? I've recently told her she was the project manager of my roof and siding being redone. She disagrees, but it's an elected position, not a chosen position. So, yeah, still her.
What was the worst financial mistake you've ever made?
Too late to say law school. Oh, I don't know. I don't think we've ever had enough money to make a bad financial mistake.
And knowing what you know now, what's one thing you would have done differently when you were younger in terms of investing?
Truthfully, I would have started save. Until we were buying a house a few years ago, I feel like we weren't super focused on saving. You feel like you're just sort of, especially when you're a young associate, you're just kind of surviving and
Yes.
going through, and you're like, I deserve this little treat and this little, vacation and this and that. And maybe you do, I didn't go off the rails, but I would have focused on a high yield savings account early and investing early and getting those skills. But again, I talk to associates about that till I'm blue, and they're just trying to survive. It's so hard to be a young associate, and so I get it too.
And our final question, we ask every guest this. In your youth, what song or album, when you heard it for the first time, had a profound impact on the rest of your life?
Well, I just yesterday convinced all of my girlfriends that we had to go see Backstreet Boys at the Sphere in Vegas. So maybe the Millennium album.
Yes.
Yes, I stand
Why?
by that. What do you mean? It's larger than life.
Explain that.
This is why we're two different generations, Ryan.
Hey, hope you enjoyed episode 211 of the Payne Points of Wealth. If you like our podcast, you love our podcast, please give us that 5-star rating on iTunes. You can subscribe. Same thing on Spotify. If you're watching this on YouTube right now, you can like this episode, subscribe to our channel, click that notification bell to be updated every week of all our new content. That's it for this week. As always, stay loose and keep an open mind.
Thanks for listening to the Payne Points of Wealth. Hopefully, you found the ideas discussed in this episode valuable and useful for your own financial journey. You can find out more about Bob, Ryan, and Chris's firm, Payne Capital Management, at bebullish.com or through the contact information found in the description of this episode in your podcast player or app. Join us next week for another episode of The Payne Points of Wealth, brought to you by Payne Capital Management. Information provided on today's show is provided for informational purposes only and does not constitute investment, tax, or legal advice. Investment is obtained from sources that are deemed to be reliable, but their accuracy and completeness cannot be guaranteed.